we'll go through it multiple rounds. In the first round, we'll understand at superficial level. In the next round, we'll go to the deeper levels and so on. Okay, and so on. So in the first go, what we'll understand here is which are the 6 fundamental rights, or how many fundamental rights are there basically. So basically there are 6 fundamental rights. Okay, basically there are 6 fundamental rights. 6 fundamental rights. So probably in our high school days and primary days also we have learnt about the fundamental rights, but the extent to which we used to learn in our high school days and now it will be different. Okay, it will be different. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. So these are the 6 fundamental rights. Okay, these are the 6 fundamental rights. Now, right to equality, article number 14 to 18, they deal with right to equality. Right to equality. Article number 19 to 22 deal with right to freedom. Article number 23 to 24, they deal with right against exploitation. Article number 25 and 25 to 28 deal with right to freedom of religion. Okay, you should not get confused here. Okay, because here it is freedom of religion, it is just plain freedom. Right to freedom of religion. Okay, religion. Cultural and educational rights, article number 29 and 30. Right to constitutional remedies, article number 32. Okay, 32. So in the first round, what you should be able to tell is, if I ask you about right to equality, range of articles.
14 to 18.
14 to 18. Next, right to freedom.
19 to 22.
19 to 22. Right against exploitation.
23, 24.
24. Right to freedom of religion.
25,
25 to
28.
28. Next, cultural and educational rights. 29 and 30. Right to constitutional remedies. 32. So this will be the first round. Okay, this will be the first round. So originally in 1950, when Constitution came into force, there was also one more right called as right to property. Okay, right to property. It was also a fundamental right. It was also a fundamental right. But now, right to property is not a fundamental right. So what is right to property? Why it is not a fundamental right? Again, detailed discussion. We will be doing it later on. But for time being, we shall understand that right to property, originally it was a fundamental right. Now it is not a fundamental right. Okay, but whether it is present in the Constitution, yes. So was deleted from the list of fundamental rights by 44th amendment. So this 44th amendment you should know. Okay, through which amendment right to property was deleted as a fundamental right. Amendment 44. Okay, in 1978. So it is made a legal right under Article 300A in Part 12. It means presently if you want to read about right to property, so where we can find?
Legal right.
Article number 300A, in which part?
12.
Part 12. Okay, Part 12. Now we have already become aware of few of the parts. So Part 1 deals with Union and its states. Part 2 deals with citizenship. Part 3 deals with fundamental rights. Part 4 deals with DPSP. Part 4A deals with fundamental duties. Okay, one by one we shall start connecting the dots. Okay, dots. So right to property is present in which part?
12.
Part 12. Which article?
300A.
300A. Whether right to property is a fundamental right?
No.
No. So whether it is present in the Constitution?
Yes.
Yes. So whenever some rights which are present in the Constitution and they are not present in the article number 12 to 35, we call them as what? Legal right, and we also call it by an alternative name called as constitutional right. So these are the most confusing things. Okay. So whether fundamental rights are constitutional rights? Yes, because fundamental rights are part of the Constitution. Whether all constitutional rights are fundamental rights?
No.
No. Okay. So there are some constitutional rights which are not fundamental. Example, right to property. Because right to property is present in the Constitution, but it is not a fundamental right. Okay. So this right which is present in the Constitution but not as part of the fundamental rights, it is also called by an alternative name called as legal right. Okay, legal right. So all the fundamental rights, they broadly fall under constitutional right. They also broadly fall under legal right. Okay, but right to property, it is not a fundamental right, it's a constitutional right. Okay, it can also be called as a legal right. On top of this, again, if you have some kind of confusions, you will suppress those confusions. You will not try to explore more about these things. So, okay, legal right, constitutional right, those who want to become a constitutional expert, those who want to argue in the Supreme Court or High Court in some cases, so they need to have a deeper understanding. Here what we are expected to become, we are expected to become jack of all the subjects. Okay, ultimately we want to crack the examination. So here we need to know where we have to stop. Sometimes what happens, we will not be able to understand some concepts completely. At a superficial level we will be able to understand. It is not that we will not be able to understand at a deeper level, we will be. But if we spend time in understanding at a deeper level, then other parts of the subject, they will get compromised. Other subjects, they will get compromised, and at the time of the examination we will not be able to revise. Okay, revise. Hence we will stop here itself. So right to property is a fundamental right?
No.
No. Right to property is a constitutional right?
Yes.
Yes. Right to property is a legal right?
Yes.
Yes. Okay, yes. So that much information would be sufficient. Some of the features of fundamental rights. Okay, features of fundamental rights. Some fundamental rights are applicable only to citizens. Only to citizens of India. Some to all persons, whether they are citizens of India or foreigners, okay, or legal persons like companies. Okay, some rights, they not only extend to an individual, they also extend to a company. For example, Infosys, TCS, LIC, all their companies, right? So they too have rights. So some are individual rights, some are organizational rights. Some are applicable only to Indians, some are applicable to Indians as well as foreigners. Okay, foreigners. Not absolute. Okay. So yesterday we discussed, again we will be discussing, for example, article number 19, right to freedom of speech and expression. So by using this right, so whatever opinion gets generated in my mind, so whether I will deliver, okay, you can, but there are some restrictions. Okay, there are some restrictions. If you feel like using an abusive word against others, you cannot use it. Okay, because there are certain restrictions. So none of the fundamental rights are absolute. They are not absolute. For every fundamental right, there is a restriction, and this restriction should be reasonable. It should be reasonable. Okay, reasonable. So whether the restriction is reasonable or not, who is going to decide it?
Court.
Decided by courts. Okay, courts. Now, for example, if we take right to freedom of speech and expression itself, someone says that, okay, you cannot use abusive words against others. So can it be considered as a reasonable restriction? Yes. Whatever the mistake the government commits, you should just close your eyes. You should never criticize the government. Can it be considered as a reasonable restriction?
No.
No. Now, which one should be considered as a reasonable restriction? Who is going to decide it?
Courts.
Courts are going to decide whether the restriction imposed is reasonable or not. Okay, reasonable or not. Next, why we require reasonable restrictions? Why we require reasonable restrictions? To strike a balance between the rights of individuals and society as a whole. Okay, society as a whole. Now, sometimes the rights of an individual will collide with the rights of the society. Okay, rights of the society. Now I will say, it's my wish. It's my wish, I will wear whatever dress I like. Okay, even I will roam naked in the Vidyagiri states. Okay, so this is my right. We cannot claim that because we also have a larger society. We also have a larger society. So here, both of them, they will clash. Hence, we require reasonable restrictions. Okay, we can claim we can have reasonable restrictions. So there are somewhat, for example, coastal areas where there are no places, where there are no people residing. In such places, you can enjoy like anything. But where civilized society exists, so whenever you are exhibiting your right, so there should be reasonable restriction. I just gave you an example. Why? To balance the rights of individuals and the rights of the society as a whole. Okay, rights of society as a whole. Between individual liberty and social control. Okay, social control again. If you start using abusive words in the public, okay, so public might become angry and it might lead to clashes and all. So to maintain that social order control, we require reasonable restrictions. Okay, reasonable restrictions. Again, the examination, they are not going to ask such kind of questions. At a superficial level, we need to know that yes, whether fundamental rights are absolute. No, they are not absolute. So there are reasonable restrictions. In the mains, we have to quote Why reasonable restrictions are required? Because to maintain, strike a balance between individuals' rights and rights of the society. To strike a balance between individual liberty and social control. Okay, individual liberty and social control. So liberty means freedom. Okay, freedom. Some are available against arbitrary actions of the state. Some against state action and against private individuals. Okay, against private individuals. So here state means
Government.
we are speaking about government. Okay, some action against state and some against private individuals. Okay, private individuals. Now, for example, next we will be discussing about article number 15 and 16, right to equality. Okay, right to equality. In that equality sense, we come across a concept called as somewhere reservation. Okay, reservation. Now, whether the provision of reservation in India exists only in the government sector or also in the private sector? Only in the government sector, governmental sector. Now, someone, if he goes and files a case in the Supreme Court, saying that when I was joining Infosys or TCS, they did not consider the reservation criteria and they did not hire me. Okay. So, whether such kind of right he claim against Infosys or TCS?
No.
They are private companies. Okay, they are private companies. So, if when in the government recruitment, when government is recruiting for UPSC or KPSC or any other examination, if they do not make any kind of provision for reservation, can he go and file a case against the government? Yes, because it is constitutionally mandated that there should be a reservation for scheduled caste, scheduled tribe, or women. So all these things, whatever reservations are there, so he can go and file a case in the court. Okay. So here what we understood is reservation is a right which a person can claim only in government jobs. He cannot claim reservation in private jobs. So it means this is a right which are available only against state. Okay. So arbitrary action, I will just take this example. In the notification, government will not make any kind of reservation provisions. So that is the arbitrary action of the government. Means whatever it feels, as per its whims and fancies, it is releasing the notification. But as per the constitution, it has to include the provisions of reservation. So and so seats are reserved for scheduled caste, so and so seats are reserved for scheduled tribe, so and so seats are reserved for OBC. So without such kind of taking all those things into account, if it releases a notification, then it will be considered as arbitrary action of the state, arbitrary action of the government. At that time, what you can do, an individual can file a case against the government. But an individual, can he file a case against the Infosys or TCS, any private company? No. Okay. It means this is an example of a right which is available only against the state and not against the private entity. Okay, not against the private entity. Some against state action and against private individuals. Okay, private individuals. So we shall take an example. Now you will take train as an example and a hotel as an example. Okay, train. So train, whether it belongs to government or it belongs to private entity?
Government.
It's a government entity. So if we take any of the hotels in the Vidyagiri, so they are all
Private entity.
okay, private entities. Now tomorrow when someone is traveling in the train, so let's assume a ticket collector will come and he'll ask for his religion or caste. Oh, you belong to so and so caste, so and so religion, you are not supposed to board the train. You please get out of the train. Okay. If someone does it, can he go and file a case against the TT? When he files a case against the TT, whether it will be against an individual or against the government?
Individual.
It will be against the government, because TT is a government representative. When you are filing a case, it will be against the government, not against the TT, because you are discriminating. Okay, you are discriminating. So we have article number 16, discrimination related article is there. Again we will be discussing. Now similarly, let's assume you will go to one of the hotels in Vidyagiri. So as soon as you go, he will ask your name. So based on your name itself, he will come to a conclusion to which caste you belong. So he will say, so such caste people are not allowed in our hotel. Okay, he is discriminating. Can you file a case against him? Yes. Okay, you can file a case against him. So this discrimination, even though he is private party, can you file a case against him? Yes. So some rights, they are not only available against the state, they are also available against the state, private party. Okay, private party. So which rights are available against the state? Which rights are available against both state as well as private entity? That we will be discussing in detail. Okay, in detail. But here what we understood, in the forthcoming discussions, the articles which follow, few of the fundamental rights are available only against state, Few of the fundamental rights are available against both state as well as against the private entity. Okay, against the private entity. Okay, private entity. Okay. Rights available against state's action violated by private individuals. No constitutional remedies, ordinary legal remedies. So now we will not understand here because we need to discuss about the article number 32. 32 called as right to constitutional remedies. Okay, right to constitutional remedies. Now, for example, I took the example of what hotel in Vidyagiri. If you go, okay, and let's assume you belong to scheduled caste or scheduled tribe, and the owner of the hotel will not allow you, saying that you belong to scheduled caste, you are not allowed to enter the hotel. Now you will go and file a case against him. Now question is whether you can go and file the case directly in Supreme Court and High Court, or you can also go and file a case in the ordinary Taluk Court and District Court. Okay. Now when we start discussing about article number 32, okay, that is right to constitutional remedies. Okay, right to constitutional remedies. So directly we can go to Supreme Court and High Court. But here in case of this discrimination based on caste, there is a separate law for it. That is SC/ST Atrocities Act. So under that act what he can do, he can file a case in the police station. Then the case will be taken to Taluk Court and all. Okay. So there is a slight difference. So now at this point we will not go into those deeper aspects. Okay. For time being we will not understand this statement completely. Once we discuss about article number 32, then we will get a clear picture. Okay. We will get a clear picture. Okay. Some are negative in character. Some are positive in character. Some fundamental rights are negative, some fundamental rights are positive. Now what do we understand by the term negative here? While discussing about a topic called as parliament, at the conclusion we discussed some points, okay, which are the factors which limit the sovereignty of parliament. Can parliament make any laws as per its whims and fancies? Whatever comes to its mind, can it make such kind of laws? No. There are some limiting factors, right? Which are those limitations?
Motion adjournment.
Yes, fundamental rights, written nature of the constitution, federal system. So these are the limitations. So there we heard that fundamental rights act as a limitation. Fundamental rights act as a limitation. Now one of the fundamental rights says that right to freedom of speech and expression. Whatever comes to your mind, you have that right to express it. So let's take an example of a newspaper, The Hindu or Indian Express, some newspaper. So they will write an article criticizing the government for one of its policies. For example, it has not implemented the national education policy properly, or it has not constructed any infrastructure related project like road properly. So they will write an article. Okay, they will write an article. So now if parliament brings a law saying that no newspaper should criticize the government, no newspaper should criticize the government. So can parliament bring such kind of law? No. Can parliament bring a law saying that no newspaper has the right to criticize government? Can parliament bring the law? No. Parliament cannot bring that law. Why?
Freedom of speech.
Because if parliament tries to bring that law, it violates which article? Article number 19, which we will be discussing later on. Okay, later on. So article number 19, it places a restriction on the powers of the parliament. It places a restriction on the powers of the parliament. So in this fashion, there are some fundamental rights which restrict the power of the parliament to make the laws. Okay, to make the laws. So hence they are negative in character. Okay, so some character place the limitations on the authority of the state. They cannot make laws, they cannot enforce the laws as per their expectations. So hence they place restriction. So which are those laws which place restriction, which are the articles which act in negative fashion? We will be looking into it later on. Others positive, conferring certain privileges on persons. So when we are saying positive, it is not positive with respect to government, it is with respect to individual. Okay, so fundamental rights have been classified into positive and negative. Positive from whose perspective? Individual's perspective. Negative from the government's perspective. So when we say government's perspective, fundamental rights is going to impose limitation, restrictions on the parliament. When we say positive, it is going to confer additional rights on the individuals. Okay, on the individuals. Okay, individuals. So are justiciable. Already we have seen, can move courts. If fundamental right is violated, what we can do? We can go to courts. Okay, we can go to courts. Are defended and guaranteed by Supreme Court. Very important. Okay. aggrieved can directly go to Supreme Court. Now next, when we start discussing about the fundamental rights, right to equality, right against exploitation, right to freedom of speech and expression, okay, if any of these rights get violated, so I mentioned about an example. So a Hindu editor will write an article against the government. Now next day the police force will come and they will arrest the Hindu editor and they will put him in jail. Now he has to go to court for remedy. So now where he can go? He can either go to Supreme Court or High Court. So both the Supreme Court and High Court, they are the protectors. Okay, they are the protectors. So an aggrieved can directly go to Supreme Court, and also later on we'll see that he can also go to High Court. Okay, so in the Supreme Court and High Court, that case will be taken, and they will see whether the government has arrested under the proper law or not, and in this fashion justice will be delivered. Okay, justice will be delivered, not necessarily by way of appeal. So next, when we start discussing about the Supreme Court, High Court and subordinate courts, so we have Supreme Court here, we have High Court, we have District Court, we have Taluk Court, and so on. So what is way of appeal? Now whatever the decision you have got in the Taluk Court, if you are not satisfied, you will appeal in District Court. Whatever the decision the District Court has given, if you are not happy, you will go to High Court. If you are not happy, you will go to Supreme Court. So if you are not satisfied with the Supreme Court's decision, there is no other option. So whatever the judgment the Supreme Court gives, that is final. Okay, that is final. So here, when your fundamental rights get violated, you need not necessarily go from District Court to High Court and then to Supreme Court. Directly you can go to Supreme Court. Okay, but these are all theoretical aspects. It is not as easy as we anticipate. Okay, if this was the case, then every individual in this country would have directly approached the Supreme Court. These are all theoretical aspects. It is not that easy. Okay, that easy. Again, we will be discussing later on. So next is from the exam point of view. If they ask you who is the defender and guarantor of the fundamental rights? Supreme Court. Okay, Supreme Court. So when a fundamental right is violated, a person has to first go to High Court, and if he is not satisfied, then he can go to Supreme Court. Okay, he can directly go to Supreme Court, not necessarily by way of appeal. Not sacrosanct or permanent. So fundamental rights, whatever were available in 1950, so whether they are sacrosanct means can they not be changed, or can they be changed? They can be changed. So the not sacrosanct or permanent means the same. It means whenever a requirement arises, whenever a need arises, so these fundamental rights can also be changed. Okay, they can be altered, they can be amended, they can be amended. So Parliament can curtail by constitutional amendment. So already at the superficial level, we have seen about the constitutional amendment, but again in the forthcoming classes, we will be discussing about a separate topic called as constitutional amendment. Okay, amendment. So we have discussed about the different types of bills also while discussing about Parliament. So which are the different types of bills? Ordinary bill, money bill, financial bill 1, financial bill 2, constitutional amendment. So in these type of bills, which type of bill requires a prior recommendation of the President? Money bill, one more. Financial bill 1. In which type of these bills is there a provision of joint sitting? Ordinary bill and next? Finance bill 1 and finance bill 2. Among which of these bills can be introduced only in Lok Sabha?
Money bill.
Yes, money bill and financial bill 1. Okay, financial bill 1. So constitutional amendment bill, it has to be introduced only in Lok Sabha. True or false? It can be introduced in Rajya Sabha. So introduction of constitutional amendment bill requires prior permission of the President. True or false? False. Okay, false. So the constitutional amendment bill has to be passed. Okay, as per article number 368. So what kind of majority is required? Generally, special majority is required. Okay, special majority is required. So here they say that fundamental rights are not sacrosanct. They can be changed. They can be amended. So how you can change? Through ordinary bill you can change?
No.
Through money bill you can change?
No.
Through finance bill 1 and 2 you can change? No. Through constitutional amendment bill you can change. Okay, change. Without affecting basic structure. Okay. So which article of the Constitution consists of the term called as basic structure? Okay. Our Constitution does not have a term called as basic structure in any of its articles. In any of its articles. Then the term basic structure, it came through which judgment? Keshwanand Bharati case. In which year? 1973. Okay, 73. So what does Keshwanand Bharati case say? Can you amend the Constitution?
Yes.
Yes, you can amend the Constitution. But you should keep in mind that whenever you are amending, whenever you are changing, whenever you are altering the Constitution, it should not affect the basic structure. Now, whether the Keshwanand Bharati case has given the detailed list of what constitutes basic structure? No, they are not given detailed provisions about the basic structure. So how did we come to know about the various provisions of the basic structure? Through various subsequent Supreme Court judgments. Through various subsequent Supreme Court judgments, we came to know that, okay, these are part of the basic structure. But there is no clear list indicating that these are the provisions which are part of the basic structure. Okay, basic structure. So this we have understood. So now what we understood, whether fundamental rights are sacrosanct?
Not.
No. Okay, can they be amended?
Yes.
To any extent?
No.
No. What we have to keep in mind? Basic structure. Okay, basic structure. Next, suspended during national emergency, except article number 20 and 21. So these things now you will not understand. We will discuss a separate topic called as emergency provisions. Okay, we will discuss a separate topic called as emergency provisions, center-state relations, interstate relations, emergency provisions. At that time we will see that these fundamental rights can be suspended. Okay, can be suspended. What is the meaning of suspension? How does the suspension take place? All these things we will be discussing in detail once we start discussing about emergency provisions. Okay, emergency provisions. So for time being, I'll skip it. So this also will skip it, not important. Okay. So under article number 33, later we'll see that these fundamental rights, they can be restricted. To whom it can be restricted?
Parliament.
Paramilitary forces, armed forces. Okay. Now, like an individual civilian, we have more rights. Right to freedom of speech and expression. If an army personnel also exercises his right, saying that I too have the right to freedom of speech and expression, he'll make a YouTube video. So look at our gun, so they are all stored here. Look at the bullets, they are here. Our helicopter is standing there. If all this sensitive information, because of his right to freedom of speech and expression, if he expresses it in the form of a video or any other media, then what happens? The enemy nation will get access to this information, and it will become very easy for them to what? Make an attack. Okay, make an attack. So hence there are restrictions on armed forces, paramilitary forces, police forces and intelligence agencies, okay, intelligence services. So they do not have right as a civilian that we enjoy, okay, that we enjoy. Then can we make a video on where the bullets are stored and where the guns are stored? No, we cannot make, because we do not have access to that place. Okay, they have access to that place, but they cannot do it because there are restrictions. Okay, there are restrictions. So generally when it comes to fundamental rights, so restrictions are more on the military person or on the civilian. So we are all civilians. So restrictions are more when it comes to enjoyment of fundamental rights on military personnel. Okay, military personnel and police personnel. Again, we will be discussing under article number 33. Most of them directly enforceable. Okay, directly enforceable. So few of the fundamental rights means directly whenever it gets violated, you have to go. You can go to Supreme Court and High Court. But few of the fundamental rights directly you cannot go. You require a special law. Okay, special law. Again, about these things we will be discussing later on. Okay, we will be discussing later on. Now we will start with article number 12. So article number 12 reference we saw while discussing which concept? Direct principles of state policy. So there under which article? Article number 36. So article number 36 speaks about the definition of state. But what did they mention? The definition is same as that of the definition of the state present in fundamental rights, article number 12. So this is the article number 12. Okay, article number 12. So under article number 12, so definition of state includes government of India. Okay, so when we say government of India, it may be executive or it may be legislative. So what do you understand by legislative organ of government of India? Government of India, central government. Which is the legislative organ?
Parliament.
Parliament. Okay, it is Lok Sabha and Rajya Sabha. So when I use the term state, we may be referring to Lok Sabha or we may be referring to Rajya Sabha. Okay, or in general we may be referring to Parliament. What is executive?
Council of Ministers.
Council of Ministers headed by
Prime Minister.
Prime Minister. So when we say state, we may also be referring to the executive as well. Okay, it depends upon the context where you are discussing. Okay, so when we are making a reference to the Council of Ministers, can we call it a state? Yes, a state. The definition of state also includes government and legislative organs of the state. Okay, here state means state government. Karnataka state government, Maharashtra government, Manipur government. So if we consider Karnataka as an example, okay, so which will be the government of Karnataka? Executive body, that is State Council of Ministers. Which will be the legislative organ of state? MLAs, members of legislative assembly and legislative council. So when we say definition of state, it's a very broader definition. It includes central government as well as state government. It includes legislative organs as well as executive organs. Okay, executive organs. It also includes local authorities. It includes panchayats. It includes municipalities. So district boards. Now these things will lead to confusion. You just ignore them. Local authorities means which we are aware. We are aware of panchayats, gram panchayat, taluk panchayat, district panchayat. We are aware of municipalities. So even these municipalities also come under the definition of state. Okay, definition of state. Other authorities, this is also very important. They may ask a question in prelims. Statutory is not of or make it as or. Non-statutory authorities like LIC. So Life Insurance Corporation of India, it's a government company. Okay, even that is considered as state. Even that is considered as state. So can we use Infosys? Can we consider Infosys as a state?
No.
Because it's a private entity. Okay, private entity. Can we consider BSNL as a state?
Yes.
Yes. So ONGC. Okay. ONGC is against a government company. It is also considered as a state. According to Supreme Court, even a private body or any agency working as an instrument of the state falls within the meaning of the state under article number 12. Very important. Now, any of you have passport, hold passport? Okay. So whenever this passport processing takes place, so where does the passport processing takes place? Yes. So passport seva kendra, right? So I don't know now exactly, but when I was processing my passport, I remember that this has been, the work has been channelized to or outsourced to TCS. Okay. So TCS company is involved in processing the passport related data and all. Okay. So when we went to passport seva kendra, so it was they were the TCS employees who are outsourced to the government. Now, TCS is a private company. Can we consider it as a state? No. But now TCS is working, okay, is working on a government project. Now, in this context, whosoever is working in TCS on that particular project, they are also considered as part of the state. So, this is the definition of Supreme Court. Supreme Court has said that even a private body or agency working as an instrument of state falls within the meaning of the definition of state. Okay, state. Now, in the examination, they may ask you, only executive organs fall under the definition of state under article number 12. False. Only executive body? No. Even legislative bodies as well. Okay. Only legislative bodies fall under the definition of state and not executive bodies. False. Only central and state legislatives and executives fall under the definition of state, and what panchayats and municipalities are excluded. False. All of them, they fall under the definition of state. Okay, definition of state, very important. Okay. Next, article number 13. Okay, article number 13. So a very important article. Okay, very important article. So here, if you have any kind of doubts while discussing also, you should raise the doubts because it's very important. Now this concept which we are going to discuss, so it will get connected to every other topic we will be discussing, which we will be discussing in the forthcoming classes. Okay, forthcoming classes. Declares that all laws inconsistent with or in derogation of any of the fundamental rights shall be void. Shall be void. Now, okay, now we have not yet discussed about the fundamental rights, right? So, in article number 24, next we will be discussing article number 24. So, article number 24 says that prohibition of employment of children below the 14 years of age. Article number what? 24 says that a child below 14 years of age should be prohibited from employment in hazardous activities. Okay, there is a provision here, article number 24, again we will be discussing later on, but we want to connect to this topic. Now let's assume central government, parliament will bring a law. Okay, will bring a law. Just to make the discussions easier. Parliament is never going to bring such kind of law. I am just trying to use this example so that it becomes easier. Now parliament, let's assume it brings a ordinary law. Okay, ordinary law saying that Employment Act 2025. So initially it will be in the form of a bill, then it will become act. For this bill to become act, what is the process involved? It has to be passed in Lok Sabha. It has to be passed in Rajya Sabha or Lok Sabha. Then it should come to Lok Sabha and Rajya Sabha with what kind of majority? Simple majority. And finally it has to be signed by President. Then it will become act. Okay, act. So in this act, there are various sections. Section 1, Section 2 and so on. Okay, there are hundreds of sections. Let's assume there is one section here which is Section 10. Section 10 says that those who are below 12 years, they cannot be employed in factories. Those who are below 12 years, they cannot be employed in factories. Means what does it mean? Those who are above 12, those who are 13 years old, so they can be employed. Okay, as per this law, below 12 years should not be employed. Means above 12 years, a person who is a child who is 13 years old, he can be employed. But what does the constitution say? After 14 years itself, a person can be employed. Now, whether there is inconsistency between this ordinary law and constitution? Yes. So this ordinary law, this is fundamental law. Fundamental law is constitution, this is ordinary law. Okay, ordinary law. Now, this article number 13 says that, declares that all laws inconsistent with or in derogation of any of the fundamental rights shall be void. Now, the law which I have taken here as an example, okay, that is Employment Act, whether it is consistent with the Constitution? No. Whether it is, now I will not use the term Constitution, whether it is inconsistent with the fundamental rights? No. Okay. Declares that all laws inconsistent with or derogatory of the fundamental rights shall be void. So, this law should become invalid. This law should become invalid. Okay, invalid. But already already Lok Sabha has passed the bill, Rajya Sabha has passed the bill, and President has signed it. Okay. Now, who has the power to declare that this law is invalid? Okay, both Supreme Court and High Court have this power to declare that this law is invalid. Okay, invalid. Now, Supreme Court and High Court, while deciding this law as valid or invalid, it is not necessary that it should declare the entire law as invalid. There are 100 sections. Okay, there are possibilities that it may declare the entire law as invalid. All the 100 sections are invalid. But what it can do, it can just say section 10 is invalid, rest all the things are okay. Rest all the things are okay. Okay. So this decision can be made by both Supreme Court as well as High Court. So that is the meaning of article number 13. Declares that any law inconsistent with or in derogation of any of the fundamental rights shall be declared void. Okay, void. So who can do it? Both Supreme Court as well as High Court can declare it. So this process of studying whether the law is consistent with the fundamental rights or not, whether the law is consistent with the Constitution or not, okay, that process is called as judicial review. Okay, so with this example you try to retain the content. Okay, trying to check whether the given law is consistent with the fundamental rights or not, so consistent with the Constitution or not, that process is called as judicial review. Okay, judicial review. So who is involved in the process of judicial review?
High Court, Supreme Court.
Supreme Court and High Court is involved in the process of judicial review. Okay, judicial review. Now we shall think from the exam point of view. Which article of the Constitution mentions about judicial review?
30.
Yes. There is no article in the Constitution wherein we will find the mention of the term called as judicial review. The term judicial review is not explicitly mentioned in the Constitution. Very important point. Okay, very important point. Basic structure doctrine, it is not mentioned in the Constitution. Nowhere it is present. Similarly, the term judicial review is nowhere present in the Constitution. But which article expressly provides for the doctrine of judicial review? Article number 13. There is a very thin line. So in the examination, if they ask, so whether the term judicial review is present in the Constitution? No. Is there any article which provides for the provision of judicial review? Yes. Which article?
13.
Article number 13. Okay, article number 13. Article number 13. Okay. So this power of judicial review has been given to Supreme Court. It has been given to High Court as well. Who has given? Constitution has given. So Constitution has given this power to Supreme Court through which article? Article number 32. It means article number 32 confers the power of judicial review on Supreme Court. Similarly, article number 226 confers the power of judicial review on High Court. Okay, on High Court. Okay, High Court. So that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. So we saw the example, right? So that law, whether it violated the constitution,
Yes.
whether it violated the fundamental rights,
Yes.
so which particular article it violated? Article number 24. Okay, article number 24. Okay, in such case, so both Supreme Court and High Court can declare a law as invalid. Okay, now it depends. If a person takes the case directly to Supreme Court, then Supreme Court will decide. If the person takes the case first to High Court, then the High Court will decide. But both of them have the power of judicial review. Power of judicial review. Okay. Yes.
Who will take the case to Supreme Court or High Court, sir?
Any of the private parties, we can take the case. We can file a case against the government saying that this law violates the constitution.
For example, if a bill is passed and it has become act.
What?
So
A
if
bill has
it
become
is
act,
pa-
okay.
So a normal person, anyone can take, or Supreme Court itself will.
No, Supreme Court itself will not take. Any of the normal person, okay, they will file a case. Generally what happens is, it depends upon the government. If BJP government has brought the law, okay, so the Congress members, what they will do, they will take this law to the court. If Congress government is in power, so BJP people will take this law to the court. So this is how it happens. But on top of that, there are many NGOs, non-governmental organizations. So if they think that this law is affecting the fundamental rights, so they will take such kind of laws to the court. Okay, there is no restriction. Anyone can take the case to the court, either Supreme Court or High Court. Yes. Once the judgment has been given by High Court, yes, we can go to Supreme Court. If the High Court decides, then it can be appealed in Supreme Court. That can be appealed in Supreme Court. There are many cases wherein High Court has given the judgment and the Supreme Court has reversed the judgment. Okay, so such instances are also available. Okay, available. So term law given wider connotation. So here, okay, we'll just focus on two aspects because we'll get confused. So while discussing about the parliament, we discussed about an act and we discussed about rule. Okay, we discussed about a term called as subordinate legislation. Do you remember subordinate legislation? What is subordinate legislation?
Work under the executive.
Detailed rules and regulations. Okay, so when we say making a law, who will make the law? Lok Sabha will pass, Raj Sabha will pass, and next president will sign. So the bill will become act. So this we call it as law making. But who will make rules? Now we have seen, right, ministries. How many ministries are there in India? 53 ministries. And I asked you to make a list of all the ministries. 53 ministries. Now if every law is administered by one or the other ministry. Okay. Now policy is administered by Home Ministry. Health related vaccines are administered by Health Ministry. Okay, Ministry of Health and Family Welfare. So now for example, we have made a, let's assume Health Act 2025. Health Act 2025. Okay, so here we will be having section 1, section 2 and so on. Next, detailed rules and regulations will be made by whom? Health Ministry. Health Ministry. So what you will do? So Health Act 2025 rules. Rule 1, Rule 2 and so on. Okay, and so on. So we learnt about the judicial review process, right? So what we can challenge in the court, whether we can challenge only this main law or can we also challenge the rules? Rules also. So that much understanding would be sufficient. So when you are challenging in the court, okay, saying that it is violating the fundamental rights, so you need not necessarily challenge permanent laws like Health Act, you can also challenge rules. You can also challenge rules. You can also challenge executive orders, okay. So executive orders, bylaw, etc. So it will lead to confusion. It will lead to confusion for time being because we have not yet discussed all the aspects. We just focus on two things. One is permanent law, another one is rule. So when it comes to judicial review process, when we are filing a case, it can be both in the context of permanent laws as well as with respect to rules. Okay, with respect to rules. Next, constitutional amendment. Now, ordinary law, in the example that we discussed, that was Employment Act. That is an ordinary law or constitutional amendment law? It is ordinary. Now, supposedly, if there is a constitutional amendment, and through constitutional amendment, they will change some part of the constitution. So, can we challenge constitutional amendment in the Supreme Court and High Court, saying that it is violating some of the fundamental rights? So, this was the question which came in front of the Supreme Court. Okay, Supreme Court. So, there are various judgments, but we look into the only final judgment. Okay. So, Supreme Court in Keshwanand Bharati case 1973 said that even constitutional amendment acts can be challenged if it violates fundamental rights. If it violates fundamental rights that form part of the basic structure and can be declared as void. A very important point to note. For example, now from article number 12, 13, 14, 15, 16 and so on, 21, 22, 23, 24 till 32, 33, 34, 35. So just to make our discussions easier, let's assume 22 and 23, they are part of basic structure. All the 33 and 34, they are part of basic structure. All the other articles, they are not part of the basic structure. Let's just assume. Okay. Now, what did the Supreme Court say in Keshwanand Bharati case? If the constitutional amendment, if it brings any changes to article number 22, if it brings any changes to article number 23, if it brings any changes to article number 33, if it brings any changes to article number 34, then such amendments can be challenged in court. Okay. Because these four articles, they are part of the basic structure. But if a constitutional amendment, if it tries to change article number 35 or 32 or 21, so such constitutional amendments cannot be challenged in courts because they are not part of the basic structure. So Keshwanand Bharati case, in Keshwanand Bharati case, what the Supreme Court said? Whether constitutional amendments can be challenged? Yes. Whether all the cases? If it violates fundamental rights that form part of the basic structure, and such amendments can be declared as void, as invalid, as illegal. Okay, illegal. Now the next question is, which of these fundamental rights form part of the basic structure? I have taken just imaginary example. Which are the fundamental rights which are part of the basic structure? Okay, there is no such standard list. Okay, there is no such standard list saying that these are the fundamental rights which are part of the basic structure. Then how will we understand? So whenever Supreme Court gives a judgment, there are many judgments. In the subsequent judgments, it will mention, okay, right to equality is a part of a fundamental right. Sorry, it's a part of the basic structure. Then we'll understand, okay, right to equality, it cannot be modified. So here there are bit complexities. We will not go into that complex web. You will only understand at the superficial level. That's very important. Okay. So let's revisit once again. Okay. Whether the term basic structure is present in the Constitution? No. The term basic structure came through which judgment? Keshwanand Bharati case. So what are the various provisions part of the basic structure? Whether they have been listed in any part of the Constitution? No. Do we find a detailed list of such things? No. How do we understand that any provision is part of the basic structure? Through many Supreme Court judgments. Now, whether an ordinary law can be subjected to judicial review? Yes. Whether a constitutional amendment can be subjected to judicial review? Yes. So, whether all constitutional amendments can be subjected to judicial review? Yes, they can be subjected to judicial review. But which can be declared as invalid? Only the constitutional amendments which alter the fundamental rights which form part of the basic structure. Then which are the fundamental rights which are part of the basic structure? We don't know. Okay, we don't know. We'll stop here itself. We'll not try to explore and try to find the list of fundamental rights which are part of the basic structure. You'll not get that list. Okay, you'll not get that list. Okay. Okay. So we understood a few of the very important things. Okay. Article number 12, definition of state. Article number 13, explicitly we found the term called as judicial review. Explicitly it has been mentioned, yes or no? No. The term judicial review is nowhere present in the Constitution. Article number 13 provides for the provision of judicial review, because in the examination they will cause such kind of confusion. Deliberately, intentionally, as per the Constitution, it says that judicial review so and so. No. In Constitution, there is no term called as judicial review. So the article number 13 provides for the provision of judicial review. Okay, provides for the provision of judicial review. Okay, so already we have made the first round. In the first round, we discussed what?
Parliament.
The range of articles which deal with right to equality. Which are the range of articles? 14 to 18. Next, right to freedom.
9 to 22.
19 to 22. Next, right against exploitation.
23, 24.
23 and 24. Right to freedom of religion.
25, 28.
25 to
28.
28. Next, 29 and 30.
Cultural and
Cultural and educational rights. Next, 32. Constitutional remedies. Now, few of the rights we have missed here. Article number 31.
right to property.
No. Okay. Article number 31 no longer exists. Now you will not worry about those things, because human brain always it tries to find the missing information. Okay. So we discussed all the articles. We have listed all the articles from 14 to 32 except 31. So what does 31 deal with? You'll just ignore it. It's not important. Okay. What does 33 deal with? We'll see later on. 34, 35 not important. So whatever will be discussed here, that would be more than sufficient. Some irrelevant articles that just exist, so they do not have any kind of relevance from the exam point of view. We'll not focus on those articles. Okay, we'll not focus on those articles. Now we'll go for the second round. Okay, we have one more third round. Okay, first round, second round, third round. Because in one go, if we try to learn all these things, then it will become very difficult. So I have made it as multiple rounds. Okay, multiple rounds. So in the second round, article number 14 to 18. 14 to 18. Article number 14 says equality before law and equal protection of laws. Okay. Now you will not understand what is equality before law, what is equal protection of laws. Now we will not understand. Later on we will understand again when we start going into the deeper level with respect to article number 14. But yes, at this point of time, just we will retain the information. Which article deals with equality before law and equal protection of laws? Article number 14. Article number 15. Prohibition of discrimination on grounds of race, religion, caste, sex or place of birth. Okay, there should be no discrimination based on race, there should be no discrimination based on religion, caste, sex or place of birth. So for example, I took the example of a hotel. So if you go to a hotel, so he should not prohibit you from entering the hotel based on your race, based on the color of your skin, based on your religion, based on your caste, based on your sex, male or female, based on your place of birth. Okay, place of birth. Okay. Next, article number 16. Equality of opportunity in matters of public employment. What is public employment?
Jobs.
Government jobs. So when it comes to government jobs, there should be equality of opportunity. So each and every individual should get equal opportunity. Now when we go and start discussing in detailed manner, at that time we will understand. So the provision of reservation, okay, in favor of scheduled caste, in favor of scheduled tribe, women, OBC. So whether it is against article number 16 or it is aligned with article number 16. You should never consider it as against article number 16. Okay, it is aligned, it adheres to article number 16. Okay, because there are limited reasonable provisions made. So that we will see later on. So equality of opportunity means you cannot say that as a general merit candidate, so some of the seats are being bagged by scheduled caste, scheduled tribe, OBC, women. No, you cannot say that because it is in tandem with article number 16. So now at a superficial level, we shall focus article number 16, equality of opportunity in matters of public employment. Okay. Next, abolition of untouchability and prohibition of its practice. Okay. So a practice untouchability. So people belonging to some caste, so they were not touched. So people never used to mingle with them, never used to have or dine with them. So all these problems. So that is dealt by article number 17. Okay. Abolition of untouchability and prohibition of its practice. Okay, practice. Article number 18. Abolition of titles except military and academic. Okay. So we have heard about the titles, right? Doctor, okay, professor. So these are all titles. So and next other titles, for example. Okay, those cannot be used. Bharata Ratna. Okay, again there is a restriction we will be discussing about later on. So previously titles Raja, Rajadi Raja, Raja Marthanda. Okay, such kind of titles you cannot use. Okay, you cannot use except military, for example Marshal, Wing Commander. So those titles can be used. Academic, Doctor can be used. Apart from these, no titles can be used. Article number 18. Article number 14. What does it say?
Equality before law.
Equality before law and equal protection of laws. 15.
Discrimination.
Prohibition of discrimination on grounds of race, religion, caste, sex or place of birth. Next.
16.
16.
Equal opportunity.
Equality of opportunity in matters of public employment. 17.
Untouchability.
18. Abolition of titles. So in the first level, if you are able to recall, so that would be sufficient. Again, the next level we'll see. And next, fundamental rights. In few of the other institutes, what I have heard is, so they engage their classes for 15 to 20 days. Okay, 15 to 20 days. Every Supreme Court judgment, so they will discuss in detail. Okay, in detail. But here we are not going to do that exercise. Okay, hardly 2 days we'll complete the fundamental rights, because the Supreme Court judgments which have been quoted in Lakshmikant, they are not beneficial from the prelims point of view. In the mains point of view, whenever you are quoting a judgment, hardly 2 or maximum 3 lines would be more than sufficient, not more than that. Okay, if you study each and every judgment to such a detailed extent, then probably you will become an expert lawyer. Okay, lawyer who can argue in the court of law. But here our goal is not to become a lawyer, right? Our goal is to crack the examination. So hence we have to understand the exam's demand and we have to prepare accordingly. Okay, prepare accordingly, because each one of the aspirant, they have the same set of resources. Lakshmikant, each individual, all the aspirants, they refer the same book. There is no other alternative book for Lakshmikant, that is Lakshmikant. For polity, apart from Lakshmikant, there are few other books, but the most famous is Lakshmikant, and no book has arrived in the market which can beat Lakshmikant. Okay, but in spite of that, all the aspirants, when every year they appear for the examination, they are not going to mark all the polity questions correct. Many of them, they mark a wrong choice in spite of going through Lakshmikant for multiple rounds. Why? Because in the end moment, they will not be able to revise. Why they will not be able to revise? Because there is a bulky content. In this bulky content, we have to prioritize the things into what is important from the examination point of view and what is not relevant. Okay, what is not relevant. So these things that we discussed, it's important. Next. Okay. Right to freedom. So again, this is the first round, not second round. So article number 19 to 22, we already seen. Protection of rights of freedom of speech and expression. So within article number 19, we have speech and expression, assembly, association, movement, residence, profession. Okay. So first is speech and expression, means whatever thoughts you have, so you should be able to express it freely. Whether it's absolute, it's not absolute. Again, there are reasonable restrictions. What are those reasonable restrictions? We'll be looking into it later on. Assembly. Okay, assembly means a group of people standing together and having discussion. So do we have such kind of freedom for assembly? Yes. Okay, freedom of assembly is there. Again, with reasonable restrictions. Means when you are assembling, can we carry arms? No. Okay, without arms, there are reasonable restrictions. Next, association. For example, you will be forming some kind of organization called as political party, Congress, BJP. All these are associations. Okay, ABVP. So all these are associations. So whether such kind of associations can be formed? Yes. So again, it comes under right to freedom. Okay, right to freedom. Next, movement. So in India, can we move from one part of the country to other part of the country without any kind of restrictions? Yes, without any kind of restrictions, we can move from one part of the country to other part of the country. But again, for everything there is an exception. Okay, but now we will not discuss in detail. For example, if you go to northeast, whether northeast is part of India? Yes, it is part of India. But even to enter few areas, we have to take a special permission. Okay, there are some areas called as in Manipur, Arunachal, not Manipur, Nagaland, we require inner line permit. Okay, so what I am saying is, for everything there is a restriction. Okay, but in general, whether we have right to freedom of movement in India? Yes, we have right to freedom of movement. Residence. So can any citizen reside in any part of the country? Yes, he can reside in any part of the country. Okay, reside in any part of the country. So can a person involve himself in any kind of profession? Yes, he can involve in any kind of profession, provided he should have the qualification. Okay, so without qualification, he cannot claim that I want to treat the patients. Okay, he need to have the qualification either BAMS or MBBS. Okay, in that fashion, after necessary qualifications are met, then a person can practice any profession throughout India. Okay, throughout India. Next, article number 20, protection in respect of conviction for offences. So we will be discussing in detail later on. So article number 21, a very important article. Every alternative year there will be a question on it. Okay, but question will not be directly based on the content which is present here. It is based on various Supreme Court judgments. Okay. So this article, protection of life and personal liberty, okay, it has so many rights within it, but they are not been mentioned explicitly in the Constitution. They are not been mentioned explicitly in the Constitution. Now in 2018, a case came. So based upon that, a new right got added. For example, now I'll ask you a question. Right to marry a person of one's choice, whether it will come under article number 19 or article number 21. Right to freedom or right to life and liberty. Okay, so we get confused. But right to marry a person of one's choice, whether it is present in the Constitution, no, it's not present in the Constitution. But Supreme Court, through its judgment, it said that right to marry a person of one's choice, it broadly falls under article number 21, that is right to life and liberty. Okay, liberty. Explicitly, right to marry a person of one's choice is not present in the Constitution, but Supreme Court has given the interpretation, so hence it is part of article number 21. Okay, so the case is Hadia case in Kerala. So one of the Hindu girl was converted into Islam. That case, her father took the case to High Court and then to Supreme Court. In the Supreme Court, the case was ruled saying that right to marry a person of one's choice, it broadly falls under article number 21. Okay, 21. Next, there is one more judgment called Puttaswamy judgment. Okay, Puttaswamy judgment. Right to privacy. So whether right to privacy is mentioned anywhere in the Constitution? When we go through the fundamental rights, nowhere you will find right to privacy kind of thing. But in the Puttaswamy judgment, so Supreme Court ruled that right to privacy, it broadly falls under which right? Article number 21. Okay, 21. In this fashion, Supreme Court, through its various judgments, it can do the interpretation and add few extra things. Okay, right to environment. Right to environment falls under which article? Article number 21. Because proper environment will lead to what? Proper life. Okay, life and liberty. So in this fashion, again we will be discussing. Again, that entire list is not required. So recent, whatever is there in the current affairs, whatever you are reading in the newspaper, if you are able to connect to the static aspects, that would be more than sufficient. Okay, sufficient. Next, right to elementary education. See here, it is 21A. Previously it was not there. Afterwards, it was added through amendment. Which amendment? We will be looking into it later on. Okay, later on. Next, 22. Protection against arrest and detention in certain cases. So this article number 22 also we will be discussing in detail in the forthcoming class. Okay, forthcoming class. So today we shall close here itself. So before we close, can we quickly recall? So which all article deals with right to equality? 14 to 18. Next, right against exploitation. Yes, right against exploitation. 23, 24. Right to constitutional remedies. 32. Right to freedom of religion. 25 to 28. Right to freedom. 19 to 22. Abolition of titles. 18. Abolition of untouchability.
17.
Equality of opportunity in public employment. 16. Okay. Next, equality before law and equal protection of laws. 14. Prohibition of discrimination. 15. Okay. Now you got an idea, right, how you are supposed to prepare. If I ask you the article number, you should be able to tell the corresponding provision. If I tell you the provision, you should be able to recall the corresponding article. So this exercise we are not going to do for the entire Constitution. All the 400 articles we are not expected to retain. Preamble will memorize. Fundamental rights, article number and provision. DPSP, article number and provision. After this, hardly around 10 more articles, not more than that. So for this entire polity subject, hardly we will be memorizing around 50 to 60 articles, not more than that. Okay, because majority of the aspirants, when they start the journey, so we have that initial aspiration, that enthusiasm will be there. So whatever is there below the sun, everything I should occupy. I should become master. In the very first attempt, I should crack the examination. So it happens. But honestly, only those who are not occupied with such kind of thoughts, they will be able to crack in the very first attempt. Because there is a hell lot of information only in polity. Again, if you go to history, modern, medieval, ancient, so much of information is there. So only those will succeed in the first attempt who have learned the art of prioritizing the content from the exam point of view. Okay, prioritizing from the exam point of view. Okay, so we shall stop here itself. Again, we shall continue discussion in the next class. So if you have any kind of doubts regarding the discussion that we had till now, so you can raise the doubts, otherwise we can close. Yes? Any doubts? No. So we shall close then.